and I'd like to welcome you to today's webinar, De-escalation and Policy. I'd like to begin. My name is Crawford Coates. I'm the publisher at Calibre Press. I'd like to begin with some housekeeping notes. Please, I wanted to let everybody know that we've muted all lines to improve the presentation experience. We will also be taking questions at the end of the presentation. However, feel free to submit your questions at any time. My friend and colleague, Shannon Piper, is the Director of Marketing at Lexipol. She's also on the line, and she'll be able to help us out with going through questions. The session is being recorded, and we will we will email you within 24 hours after the presentation a link where you can access the recording, which we would then encourage you to share with your colleagues. Today's presenters are two people I've known for a long time and have the utmost respect for. Chief Ken Wallentine is a special agent who directs the Utah Attorney General Training Center, overseeing use of force training and investigation in cold case homicide investigation. He's also a consultant and senior legal advisor for Lexipol. Ken has formerly served as Chief of Law Enforcement for the Utah Attorney General, serving over 3 decades in public safety before a brief retirement. He also serves as the chairman of the Peace Officer Merit Commission of the Greater Salt Lake County. Laura Scarry, our other presenter, is a partner with Scarry and is an attorney for Lexipol. She served as a police officer for the city of Lake Forest, Illinois from 1986 to 1992 and has since built a practice representing police officers, supervisors, administrators, and police agencies they work for against claims covering a wide array of law enforcement issues, including excessive force, deadly force, search and seizure, malicious prosecution, failure to train, duty to protect, police pursuit, employment discrimination, in-custody deaths, and racial profiling. Laura and Ken are both certified force science analysts. We're really looking forward to today's webinar, and with that, I'll let you take it away, Ken. Thank you.
Thanks very much, and good morning, everyone. You know, we have to start the discussion by taking a minute to explore what exactly is de-escalation. You know, if you look in the dictionary, it defines de-escalate simply as decrease in extent, volume, or scope. Nothing about police officer actions. And although our discussion today is policy-driven, not tactical, most definitions of de-escalation describe tactics, things like slowing situations down, using distance and cover, speaking slowly and trying to negotiate, and responding proportionally from a range of options. De-escalation isn't new. Perhaps you learned about it in the police academy, and if you're a more veteran cop like me, de-escalation is a term for something that you've done over your entire career. I venture to say that most police officers use de-escalation tactics, whether they realize it or not, almost daily. It's simply part of the job. However, in the last 5 years or so, we've seen an increasing focus on this term from those outside law enforcement. Lay people in the media really use it to mean a lot of things, and it's often employed in a magical sense, sort of, as if it's simply a button a cop could have pushed to create a completely different outcome to an incident. And, well, that kind of thinking can quickly lead to misunderstanding. In a case, Humphrey versus Town of Spencer, the plaintiff sued the police, claiming that the department had a custom, policy, or practice of failing to adequately train its officers to de-escalate. Well, the court dismissed the claim because the plaintiff couldn't point to a meaningful difference between use of force training that taught officers to consider force proportionate to the need and some program that taught more precise, quote, principles of de-escalation of force, close quote. So courts that have discussed failure to de-escalate or failure to provide de-escalation training assume that we all know what de-escalation means. And most cops understand that de-escalation is any step intended to make the situation safer and reduce the need to use force to resolve the situation. Well, we of all people must be careful in our efforts to promote de-escalation and remind ourselves, the so-called experts out there, the media, and the public that de-escalation isn't always possible. Police confront situations that are tense, uncertain, and rapidly evolving. While we do our best to slow things down and make time our friend in resolving crises, we're often not able to control the intensity, the violence, the tempo of an urgent call for service. So let's look at 2 fairly recent high-profile incidents that illustrate the confusion that can happen with de-escalation discussions. The shooting of Philando Castile made national headlines, and it sparked numerous protests, in part because it was partly live streamed by Mr. Castile's girlfriend, but also because it appeared to many that this was a completely preventable shooting. On July 6, 2016, Officer Geronimo Yanez and another officer stopped Mr. Castile's vehicle under suspicion that the driver had been involved in a robbery. When Officer Yanez asked for Mr. Castile's license and registration, Mr. Castile complied, but he also told the officer that he was carrying a gun. Officer Yanez told Mr. Castile, "Don't touch the weapon, don't pull it out." Mr. Castile responded, well, he wasn't pulling it out, but Officer Yanez, perceiving a threat, fired his weapon 7 times, killing Mr. Castile. In a jury trial, Officer Yanez was cleared of all charges, but his department fired him the very next day after the verdict. Well, after the shooting, some experts, or so-called experts, rushed to claim that de-escalation training could have altered the outcome and could have prevented the shooting. Well, the shooting investigation report noted that Officer Yanez had only 2 hours of de-escalation training, and his attorney countered that Officer Yanez tried to de-escalate the situation in the very few seconds before Castile reached for his gun. Some situations simply evolve too rapidly to allow time for any de-escalation efforts. Nonetheless, the case prompted a major shift in Minnesota law enforcement training. The Minnesota legislature recently approved a plan that requires Minnesota Post to train every one of the state's nearly 11,000 police officers in de-escalation techniques for 16 hours. Minnesota Post estimates that it may take as long as 5 years to deliver the training to all incumbent officers. Well, the legislature did step up to pay for it. They allocated $6 million to pay for the training beginning in 2018. Well, many of you have also heard about another recent incident where de-escalation led to a very different outcome. On May 16, 2016, Officer Stephen Mader of the Weirton, West Virginia Police Department responded to a report of a domestic incident where he encountered a man with a gun, and the man asked Officer Mader to shoot him. Well, in the Marine Corps, Officer Mader had undergone de-escalation training, and he was confident that this was a situation where he could attempt de-escalation. He began speaking in a calm voice, and he didn't react to the man's attempts to provoke him. 2 additional officers rolled up on scene. The armed man walked toward them waving the gun, and one of the other officers shot and killed him. The gun, incidentally, was later found to be unloaded. Of course, nobody knew that at the time. Officer Mader was terminated for, quote, failing to eliminate a threat, close quote. The other 2 officers were cleared, and they returned to work. Well, now the ACLU has sued the city on behalf of Officer Mader. From looking at these 2 cases, it's easy to see why officers can be confused. In one case, an officer doesn't de-escalate, but instead shoots, and he's cleared by a jury, but still fired by his agency. In another case, an officer does de-escalate, doesn't shoot, isn't charged, but he's also fired. You might be thinking, de-escalation is a lose-lose situation. Well, there's a deeper contradiction here, too. For years, police departments have been taught and subscribed to the broken windows theory of policing, and cops are in part measured by the number of arrests we make. Now we're being told that policing goes far beyond just enforcing the law, as if we didn't know that already, and that we need to engage with people in different ways. A few states, such as Minnesota, are mandating de-escalation training. Many agencies voluntarily provide de-escalation training for their officers, including departments in New York, Chicago, Dallas, and Las Vegas. Some other departments, such as Ferguson, Missouri, are requiring officers to receive de-escalation training under a consent decree with the U.S. Department of Justice. Some early statistics tell us that de-escalation is effective in reducing force. Obviously, less force means less liability, less litigation, potentially saving scarce budget dollars available for other core policing needs. The Dallas Police Department reported an 18% drop in use of force the year after it instituted de-escalation training. Dallas has also seen a dramatic decrease in excessive force complaints against its officers, 83% drop since 2010. Just 4 years after rolling out de-escalation training, Las Vegas Metro PD reported a 50% reduction in officer-involved shootings. Coincidence or causation? Well, we don't know. Better research may tell us. Another research report looking at a few metropolitan agencies found that those with de-escalation policies had higher numbers of officers killed or assaulted. Again, however, this research shows correlation, not causation. So we need to be very, very careful to jump to conclusions about de-escalation and policy language and training. There are many different opinions out there, and there are also factors in our community that we've simply never dealt with before. There are also changes in our applicant pool. We're increasingly recruiting from applicants who've grown up in a world that doesn't foster interpersonal communication skills as much as we did 50 or 25 years ago. Now, I mentioned earlier that teaching and practicing de-escalation is really most appropriate in training scenarios. That's something police executives must take very seriously because we're starting to see failure to train on de-escalation pop up in lawsuits. If a plaintiff claims that an injury resulted from the agency's failure to teach de-escalation principles, the claim falls into the failure to train theory of civil rights liability. That comes from a case, City of Canton, Ohio versus Harris, in which the Supreme Court held that to show the agency liable under civil rights theories, the plaintiff must first show that the police violated some constitutional right, such as the right to be free from excessive force. Second, the agency's policy of not training officers on de-escalation amounts to, quote, deliberate indifference, close quote, to the plaintiff's constitutional rights. And third, that the plaintiff's injury would have been avoided had the police department properly trained its officers, for example, in de-escalation. Another key case is Thomas versus Cumberland County, a Third Circuit case from 2014. Lawrence Thomas sued after he was attacked at the hands of other inmates at the Cumberland County Correctional Facility. The attack occurred after a several-minute-long verbal argument between Thomas and a group of inmates in the presence of some corrections officers. Thomas sued Cumberland County and the policymakers at the jail for their failure to properly train corrections officers, or so he alleged, in conflict de-escalation and intervention techniques. Now, the court quoted Canton, underscoring that failure to train requires deliberate indifference. But it also stressed another finding from Canton, that an identified deficiency in an agency's training program must be closely related to the ultimate injury. Or in other words, the deficiency in training must have actually caused the constitutional violation. And in this case, the court found genuine issues of material fact as to whether the county exhibited deliberate indifference to the need for pre-service training in conflict de-escalation and intervention, and whether the lack of such training really had a causal relationship to Thomas's injuries. So the Court of Appeals vacated a grant of summary judgment and sent it back to the lower court. In another case, Valdez versus City of Philadelphia, that's a Pennsylvania case from just last year. The plaintiff claimed that officers banged on his car window as he was seated at a gas station. Now, he alleges that officers broke out his window, dragged him out of the car, and beat him. Well, the officers testified that they found him passed out, opened the car door, and removed his syringe and drugs. Then one of the officers shook Valdez slightly to wake him up, and Valdez suddenly came alive and punched at the officer. The officer deployed a taser, retreated, shut the car door. Another officer broke a car window to assist in controlling Valdez. Valdez sued. He claimed that the police department lacked adequate training in de-escalation tactics, and the court held that there was enough evidence that a reasonable jury could determine that the agency's failure to train constituted deliberate indifference. This is one case where we're seeing de-escalation training really play a part in the litigation, and the court particularly emphasized a U.S. Department of Justice finding that the police department failed to provide consistent training in its use of force policies. Thus, the court denied the city's motion to dismiss and sent it to a jury to consider the adequacy of de-escalation training in the police department. The bottom line from these cases, this is an area of high risk for law enforcement agencies. Your use of force training should include a discussion of de-escalation tactics, and you should have a way to document that training and store those training records so they're accessible in case of litigation. Well, I'm curious. We want to know, does your department train on de-escalation tactics? So, Crawford, I'm going to ask that we can shift to a poll here. So you see a poll there on your screen. Go ahead and make a selection. None of the organizers or panelists vote, and in just a very short time, we'll reveal the results to you.
Thank you, Ken. This is really interesting stuff. There's a lot of interest in it at the moment as well. So I'm seeing some preliminary numbers here, but I won't tell you what they are. In a moment, I will go ahead and close the poll. It looks like all votes have been cast, and we'll see what those numbers are.
Well, I have a prediction. I'm going to hold that here. Yeah, well, okay. I would have said about 2/3. So Just 70%, just a little better than 70% telling us that the department trains on de-escalation tactics, and that's really not a big surprise to us. Well, let's shift our discussion to incorporating de-escalation principles into the policies, and for that I have my very good friend and colleague Laura Scarry, and she's going to guide us through best practices in de-escalation policies that we can actually put to work in our agencies. Laura?
All right, thank you so much, Ken. Good morning and good afternoon to everyone in attendance. Today we're not going to talk a lot about specific de-escalation tactics. Discussion of specific tactics is more appropriate in training or procedures. Instead, we're going to try to solve the question of what's the appropriate way to address de-escalation in policy. Let's start by looking at how some major law enforcement organizations address this. Many of you are probably familiar with the Police Executive Research Forum, otherwise known as PERF. In the report last year, they made this recommendation: adopt de-escalation as a formal agency policy, making it clear that de-escalation is the preferred approach in many situations. Next, we look at the model policy issued by several police organizations earlier this year. 11 law enforcement, leadership, and labor organizations across the country, including the International Association of Chiefs of Police, NOBLE, and the Fraternal Order of Police collaborated to develop a use of force policy that would serve as a template for other law enforcement agencies to compare and enhance their existing policies. They developed a national consensus policy on the use of force that requires officers to use de-escalation whenever possible and appropriate before resorting to force. Finally, the final report of the President's Task Force on 21st Century Policing weighed in on de-escalation. For those of you not familiar with the task force, in 2014, President Barack Obama signed an executive order establishing the task force. The members of the task force included law enforcement officers, social activists, and academics, and together their goal was to develop recommendations for local, state, tribal, and federal agencies to develop police practices to accommodate the changing social landscape. The task force focused on 6 core areas. 1, building trust and legitimacy. 2, technology and social media. 3, community policing and crime reduction. 4, training and education. 5, officer wellness and safety. And then finally, policy and oversight. The report stresses the importance of de-escalation and recommends that departments have comprehensive policies in a number of areas that emphasize de-escalation. However, when we look closer, we see that the recommendations blur the line between policy, procedure, and training. At Lexipol, we try to keep policy separate from procedure and training. By all means, officers should be trained on de-escalation tactics and procedures for incidents like mass demonstrations and responding to individuals with mental health concerns can help officers minimize the use of unnecessary force. But integrating de-escalation as a required step or technique into a policy is something else entirely. All right, let's go to our next audience poll.
Here's our next poll, Laura. Let's see. Does your agency's use of force policy incorporate de-escalation steps wherever possible and appropriate? Select one of the following: yes, no, and not sure. And again, we'll just take a few seconds to wait for these answers to come in.
Okay, and then in other words, for those of you contemplating this, we're asking, does your policy incorporate a use of force continuum, or does your policy require that specific steps need to be taken in response to certain verbal or physical threats presented by a suspect or an individual? And I'm actually very curious to see what the poll results are.
Okay, it looks like it's closed, so there we have it. 57%
yeah.
Yes, 27% no, and 16% aren't sure.
Okay, so this is very interesting, and I'm going to make a final comment about this poll at the end of the presentation after we discuss the integration of de-escalation into our policy. So can you move to the next slide? Okay, at Lexipol, we do incorporate the concept of de-escalation into policy, but we're very careful about how we do so. Here are 5 key policies where references to de-escalation are appropriate. First, we have, of course, the main policy, which is our use of force policy. the crisis response unit, crisis intervention incidents, civil commitments, and last but not least, civil disputes. The use of force policy is probably the first place you'd look for de-escalation language. However, this is also a place where agencies can easily get into trouble. If you fill your use of force policy with all sorts of steps that an officer must go through or complete before they employ force, you can inadvertently create a situation where the policy is actually used against the officer in court, even when his or her actions were completely justified. That's where careful crafting of policy language is so important. Here you see one of the introductory sentences in Lexipol's use of force policy. Note how it stresses the department's commitment to minimal use of force without boxing an officer into having to take specific steps or follow a continuum to de-escalate before using force. Ultimately, you want officers to be using good judgment and doing what they can to avoid the need to use force in the first place. How do you do that? By stressing the factors officers should consider before using force. And here are a few of them that we stress. The effects of drug or alcohol, the individual's mental state or capacity, the availability of other options and their possible effectiveness, the risk and reasonably foreseeable consequences of escape, the apparent need for immediate control of the individual or prompt resolution of the situation, and whether the conduct of the individual being confronted no longer reasonably appears to pose an imminent threat to the officer or others. In addition, we note that officers using pain compliance techniques should consider whether the individual can comply with the officer's orders and whether the individual has been given sufficient opportunity to comply. Do you see the difference here? What we are not doing in the policy is laying out specific de-escalation tactics and saying they must be attempted in a certain order. What we are doing is stressing the seriousness of the use of force and the need to weigh many factors and situations that are always dynamic and ever-changing. Those factors in that decision-making process are then taught and reinforced through training and procedures. Obviously, it's important that you have a deep understanding of your use of force policies because it's very easy for a layperson or a reporter, as we all know too well, to scan a policy and claim that because they are unable to locate a specific word de-escalation in the policy, the department or agency doesn't support the concept of de-escalation. If you can point to where the principles are and not the buzzwords are located, you can easily deflect that argument. One area of law enforcement where we often see a call for de-escalation is dealing with individuals who are suicidal or who have taken hostages or otherwise barricaded themselves. If officers have time to call the crisis response unit, they often have time to attempt to verbally de-escalate the situation. That's why, as you can see in the language on this slide, your crisis response unit policy should make clear that the officers staffing the unit have special training, including training in de-escalation. Lexipol's crisis response unit policy establishes the unit and outlines responsibilities for training and equipment. What it doesn't do is go into detail on tactics or procedures. That's because tactics are dynamic, often change, and are best covered in training. Let's consider a couple of examples on that point. Those of you who have been around a little longer probably recall the North Hollywood shootout in 1997. In that incident, officers faced suspects who were equipped with more powerful weapons than the initial responding officers. As a result, it is not uncommon to see agencies today equip their officers with semi-automatic rifles. Another example is the Columbine High School shooting in Littleton, Colorado. That incident changed response protocols to active shooter incidents. If you recall, the traditional tactics of surrounding the building, setting up a perimeter to wait for more specialized SWAT units failed dramatically. As a result, police departments changed their response tactics and agencies now train officers facing similar situations to immediately move toward the gunfire and seek to neutralize the shooter. Both of these situations underscore that training and equipment needs will evolve and should remain flexible and able to change as threats expand. But policies are documents that often require a long review and approval process, and for good reason. They help employees establish boundaries for what the organization considers acceptable behavior in certain situations. They are not conducive to change in response to the latest and greatest tool or fancy buzzwords. So it's best to use policy to highlight the agency's goals and then use procedures and training to outline the specifics. And that goes with the concept of de-escalation as well. Closely related to hostage barricade incidents are incidents where officers must deal with persons experiencing some kind of mental crisis, which oftentimes does not involve a criminal act. Too many of these incidents end with injuries and deaths that may have been preventable. This is also an area where courts have weighed in and will continue to do so as law enforcement officers continue to serve as de facto mental health responders, whether we like it or not. Recently, a federal court judge cleared the way for a trial in the case of an individual named Mohammed Bah, B-A-H is the spelling of the last name, a 28-year-old student killed in his home by NYPD officers after his mother called 911 for assistance to take him to the hospital. In that case, Bah's mother, who lived in another country, decided to visit her son due to her concerns that he didn't sound right when they spoke on the phone a few days earlier. When she arrived in the country, she went to her son's apartment, and when she saw him, she observed that his appearance changed dramatically, and that he told her that he was Jesus Christ and said a whole bunch of other things that just, excuse me, didn't make any sense to her. She tried to convince him to go to the hospital, but he wouldn't. So the next day, she contacted the NYPD for assistance in getting her son to the hospital. She told the NYPD that her son was alone in his fifth-floor apartment, was not violent, and did not have any weapons. Patrol officers, a hostage negotiation team, and what they call a technical assistance response unit responded to the apartment, where they breached the door and entered the apartment, after which Mr. Bah was subjected to 2 tasers, a less lethal projectile shotgun, and 8 gunshot wounds from 3 different officers who fired their firearms. The NYPD was subjected to a lawsuit, and they later filed a motion for summary judgment, which the court denied, and the claims of unlawful entry and excessive force against the police officers who responded to Mr. Bah's apartment are now proceeding to trial in, I believe it's the first week of November this year. So it's important that this policy stress the need to go slow, evaluate, and when possible, attempt to de-escalate. This is also a place where your policy may want to get more specific. For instance, the Lexipol policy outlines factors for officers to consider after immediate safety concerns are resolved. Things officers should generally do include introducing yourself and attempting to obtain the person's name, being patient, polite, calm, and courteous, and avoiding overreaction, speaking and moving slowly and in a non-threatening manner, moderating the level of direct eye contact, and demonstrating active listening skills. Things officers should generally not do include, you can go to the next slide, using stances or tactics that can be interpreted as aggressive, allowing others to interpret or engage the person, cornering a person who is not believed to be armed, violent, or suicidal, arguing or speaking with a raised voice, or using threats to obtain compliance. Note again the careful wording. These are not steps an officer is obligated to move through. These are considerations for them to include in the decision-making process. And note that the language is in complete alignment with the Graham standards of the infamous Graham v. Connor case enunciated by the United States Supreme Court in 1989. Also, keep in mind that scenario-based training is a great way to reinforce your agency's crisis intervention policy. At the end of the webinar, Crawford will give you a link where you can access a couple of training bulletins on this very topic. Very closely connected to crisis intervention are calls involving civil commitments. Your state likely has a specific term or code for these commitments, but the gist is the same. You're basically on a medical call. It's not a police-related issue. You're just trying to get someone to the hospital, and therefore the Graham standard can actually work against you in many of these cases. A recent Sixth Circuit case by the name of Hill versus Miracle highlights the issues that can arise. There, a deputy responded to assist paramedics dealing with a patient in a diabetic distress. The patient fought the paramedics, preventing them from treating him and potentially endangering his life. The deputy applied a single drive stun using his taser, and paramedics were able to gain control and administer the proper medicine to end the diabetic emergency. But, as we often see, the patient later sued. The Sixth Circuit ordered the suit dismissed and laid the foundation for a new 3-question test to determine excessive use of force in a medical emergency. Ken has a great article on this case in the August issue of Police Chief magazine. At the end of the webinar, we'll give you a link where you can have access to that very important article. As you can see, our courts are recognizing there is a difference between a person experiencing a medical emergency and a person committing a crime. Your policy should also do the same. Our final policy area is civil disputes. Again, these are generally civil and not criminal matters. Our objective is to avoid having to take any action. There are 3 types of civil disputes that tend to cause trouble for officers. When the officer is called to respond to a vehicle repossession in progress. Another common scenario is when the officer is asked to provide standby assistance so an individual can retrieve his or her property, typically the result of an order of protection. And finally, when officers respond to a landlord-tenant dispute. All of these incidents involve individuals whose emotions are not only running high, they are basically on supercharge mode. No doubt officers will need to rely on their verbal judo and other communication skills, and your policy should remind officers of that. So from looking at these policies, what are some broad guidelines that we can draw? First, make sure you're not adding any additional standards to your use of force policy. That policy is best written to align with the Graham v. Connor standards and not require officers to move along any kind of use of force continuum. Second, when policy does recommend the use of de-escalation tactics, use the word should, not shall. Good policy is written in a way that makes clear when things are required and when there is room for deviation from policy. The word should doesn't mean that an officer can ignore the policy, but it provides room for those dynamic, unforeseeable situations officers may encounter. Give special consideration to incidents involving people in crisis. This is really where de-escalation is essential. If you look at many of the high-profile use of force cases where officers' actions have been questioned and where officers have lost their jobs, many of them involve people who are in crisis. Our standard methods of gaining compliance simply don't work on people who are seriously mentally ill, who are under the influence of serious mind-altering drugs. Policy should make clear that de-escalation should be considered in these situations. Finally, craft policy carefully to ensure that you're not boxing officers in. There are countless ways for your agency to emphasize the importance of de-escalation. Recognize what belongs in policy and what's a better fit for procedure and training. With that, I'm going to turn it over to Crawford.
Well, thank you so much, Laura, and also thank you to Ken. We actually have quite a lot of questions coming in right now. I'm going to start with the first one that came in. And the question is this: understanding that it's difficult to predict where the court and state legislatures are headed, do you foresee a time where officers have a legal obligation to employ de-escalation tactics in specific situations?
Well, Laura, I'm going to let you jump in and take that one first.
Well, I think it is true that we can't predict where the courts and state legislatures are headed, but there's always a moral obligation to engage in de-escalation tactics, but there may not be a legal obligation at this particular point, because what the courts have emphasized thus far, and what I mean by the courts is we're talking about the United States Supreme Court in Graham v. Connor. In that case, the Supreme Court made it abundantly clear that the test of reasonableness under the use of force, which is analyzed under the Fourth Amendment, is, and I'm quoting this from the United States Supreme Court, it's incapable of precise definition or mechanical application. Therefore, while we should incorporate the concept of de-escalation of the use of force in our policies, we need to be mindful of the fact that it is not possible to outline with specifics when the use of force should be used or when we should de-escalate that use of force. So I'm hoping, that our courts are going to, I don't want to say incorporate the vagueness of the reasonableness standard, but, almost 30 years ago, our Supreme Court justices, they were very mindful of the fact that in these rapidly evolving situations, it's very difficult to go through or incorporate a number of steps regarding the use of force, and I think likewise that would apply to de-escalation as well.
Well, on this point, Laura, I completely agree with you, and I just would draw our attention back to that case that I mentioned earlier, Humphrey versus Town of Spencer. And I think that one of the reasons that the agency did as well as it did there and got a dismissal is because, one, the agency had work de-escalation into its training as well as some mentions in policy, and the plaintiff just couldn't point to a specific lack or a specific deficiency. That said, I think we all understand that plaintiff's attorneys will, and I think they have a duty to, they're going to push for new theories to hold officers responsible in force situations.
I agree with that.
Yeah, there's a lot to think about there. Here's another question we have. This one is, the Stephen Mader case brings up the question, if an officer chooses to use de-escalation and then a civilian or someone else is harmed, can the officer be held liable?
Wow. Well, who is it that, maybe Laura can remember the exact quote, that you can sue for a hot cup of coffee. You can sue for anything. The question is whether the agency will ultimately be required to pay and be held liable. I've got a crystal ball sitting right here in my office. I'm looking into it right now, and I think the question is probably not. Really, under our current state of Section 1983 litigation civil rights statutes, the answer is no. Now, could there be some facts thrown in there showing that the officer made some other misstep? Sure, but if we take exactly the Stephen Mader case and there was some harm that resulted, the answer right now is no.
Laura, do you care to jump in there at all, or?
No, I think I agree wholeheartedly with what Ken stated. He highlighted the fact that plaintiffs' attorneys, they're always going to come up with different theories to hold officers responsible. You know, I usually call them the flavor of the month, you know, because each year we're, as defense attorneys, we're dealing with ever-evolving theories that have been developed by plaintiffs' attorneys. So as long as, you know, we can articulate, you know, whether or not the officers acted reasonably, you know, in responding to the situation, then more than likely the officers will not be held liable.
Okay. All right. Well, here we have a question from Sarah. And Sarah wants to know if de-escalation can ever include officers de-escalating themselves or each other, or is it always officers calming their subjects?
That's an interesting question. How about that, Ken?
You know, and so last night on the way home, I did something extremely rare for a 35-year veteran who now always works day shift and is mostly in an administrative investigative role. I made a traffic stop because the guy in front of me was just being crazy, and you know, I de-escalated myself before I got out of my truck and walked up to him. Yeah, there are situations where I think that de-escalation techniques do work well for ourselves. Like, I'm in a family. We've been cops in my family since 1869, and I got 2 kids that are cops, but I also have a daughter who's a therapist, and it's interesting. She's talking to her cop brother and sister all the time about, you know, things that you can do to make your day go better, and one of them, frankly, is a self-calming mechanism before you're in a difficult situation. I think Sarah's question taken to the next step, that is, can we de-escalate other officers? That's an intriguing question, and the better question, I think, from a legal perspective is, do we have a responsibility to do so? Well, we certainly have seen in a number of use of force lawsuits where officers have been sued for the theory of failure to intervene, and this is particularly applicable to supervisors, where an officer's use of force is later determined to be excessive according to a court, and there are other officers around who failed to stop that use of force, and in certain circumstances we do see some liability there. It's not common. Again, this points to a comment that Laura made. We've just got to be very, very careful about setting up expectations that we will have this magic 8-ball, this magic button that we can push and de-escalate every situation. We can't, and sometimes that includes other officers. We don't know what's what's going through their head. So, Laura, anything to add?
Yeah, I agree with that. I'm going to highlight the fact that the failure to intervene theory, while it's a common theory that plaintiff's attorneys will use in pleading their cases, the actual liability for failure to intervene, it is rare. And that's because other officers on the scene, typically in these types of cases, you know, we've got the issue of the potential use of force or the potential use of deadly force, and it's hard enough for the individual officers to focus on themselves and the subjects that they're confronted with, let alone try to focus on what the other officers are doing. And typically, the case will be when officers are being deposed in the civil lawsuits against them, when they're asked questions about what their fellow officers are doing, they really don't know. And so how is it that they can predict, you know, what their fellow officers are going to do in response to any given situation? It's very difficult to predict. So I agree with what Ken's position was on that particular issue.
Okay, well, thank you guys. And the questions keep coming in, so as long as we have the time, I'm going to go ahead and ask them of you both. How can we, this one comes from Kevin. Kevin would like to know how we can effectively teach de-escalation tactics to patrol officers in a training environment.
Ken, that's not my area of expertise. I don't do any training for police officers, so I'm going to let that one go to you, if you don't mind.
Sure. No, thank you. First off, I made a point early on that our recruit pool is changing, and that's, you know, you ask anybody who's doing hiring, and they'll agree with me on that. We are seeing officers recruited from ranks of folks that grew up with devices. They grew up with cell phones. They grew up texting. They grew up instant messaging, and they didn't necessarily grow up in, you know, Girl Scouts, Boy Scouts, Brownies, football teams. My daughters all played soccer, and that certainly gave them a flavor for some socialization in a very different way. We have to recognize that that's the case. So there are times when we've just got to teach cops core interpersonal communication skills, including de-escalation, that we just didn't have to worry about when I started a very, very long time ago. We'll leave it at that, well over 3.5 decades ago. We have seen effective de-escalation training primarily in scenario-based training. Here in our agency, we've launched a program for officers across the state called Street Smart De-escalation, where we provide 4 hours of classroom instruction that is complemented by some live scenarios in the classroom, and then they come into a virtual reality center. We have a Virtua V300 virtual reality simulator here in our office, and the Virtua folks have a number of fabulous scenarios that teach de-escalation, and we offer that training at officers here in our state. We have found that the instruction is far, far more effective when officers are given scenario-based opportunities to learn any communication skills, but particularly de-escalation skills. And I certainly would make that recommendation. There's a lot of folks out there in the commercial market providing de-escalation training because it is, as Laura says, it's a flavor of the month. It's a flavor, I think, that's here to stay. So, you know, if you're looking at a program, I'd say look very carefully at certainly the competence of the instructors, but also whether they offer interactive scenarios that your officers can learn from.
Thank you, Ken. And if I may plug Calibre Press here, we do a lot of de-escalation training and communications training, and in particular our course, Read, Recognize, and Respond, which has been, as you say, I mean, not flavor of the month per se, but extremely popular. It seems that a lot of people are sort of thirsting for this information. More questions?
Well, and the good thing about the Read, Recognize, and Respond program is that sure, you do learn about de-escalation. It's a little broader. It really sharpens your interpersonal communication skills in dealing with persons that are emotionally disturbed in some kind of emotional crisis. And hey, let's face it, Crawford, police don't get called to a situation where folks want to talk very calmly about some argument over the dinner table. We get called to situations where we've got to be on our very A game in our communication skills, including bringing other people down from their D game or up from their D game into at least their B game or A game.
Yeah, if it's possible, right?
Sure.
And that kind of brings me to the next question. This comes from Craig. Craig says it seems to him that a lot of the time when he's attempting to de-escalate a situation, it makes things worse because, in his opinion, the person that he's dealing with thinks that they're being condescended to. Is there a better way to approach de-escalation? And this is something that, in our programs we talk about a lot. Is there a better way to approach de-escalation, in your opinion, so that the subject that you're dealing with doesn't feel condescended to?
Wow.
Yeah, wow.
Wow. That's I really, from a legal aspect, I mean, that's a difficult one to address. I mean, that's more of a training issue in terms of the methods of how to de-escalate without sounding condescending. And I have to agree, I see why that question is being asked because, oftentimes we'll see, after the fact we can hear a radio transmission or there's some sort of recording, by the negotiator who's actually talking to the individual. And in some ways it does sound condescending. But I don't know from my own personal experiences, whether or not that's the appropriate way or not. All I know is that from an attorney perspective, we rely on the expertise of, the mental health professionals or, the other individuals that are, basically training the police officers on how to communicate with these individuals. So if there is a better way to, so-called talk to these individuals without sounding condescending, I mean, I think that's got to come from, the mental health field, which then translates into the training that the officers are receiving. And I don't know if I'm way off base, Ken, but I'll let you jump in on that too.
Yeah, so we've obviously, when we developed our Street Smart de-escalation course here in the office, we relied on mental health professionals to help us to design that course. And clearly, Craig's question is, I think, particularly important to all of us that recognize there are times that no matter what we try, we're not going to sound great. And just the fact that you're trying, I think, is critical. I have a great advantage. I'm married to a wonderful woman, have been for nearly 40 years that in the medical field. And when I am speaking in a way that's condescending, I hear about it pretty quickly. And I have also, there have been times when I've been faced with a difficult conversation, and I role-played that with my daughter, the therapist. I realize you're going out on a call, you can't do that. But some of the pointers that I have picked up from role-playing with either my wife or, and usually that's not a voluntary role-play, but with my daughter, those lessons carry over. So I would say practice. Just practice crisis communications. Tough question.
Yeah, and if I could add also that I think officers need to be, and I don't think this really impinges on the legal aspect, but I think officers have to be aware in training that that communications are sometimes nonverbal as well.
Yep.
Yeah.
We have a question here from John, and this is for Laura. Let's start with Laura at least. Do you recommend incorporating a standalone de-escalation policy as opposed to incorporating it into various existing policies, such as use of force, handling the mentally ill, and so forth? Hello?
Laura, did we lose you?
Hello? Can you hear me, Ken?
I can hear you.
Okay. Well,
okay. I just got a message from Laura. She said that she couldn't hear Crawford. So the question is.
Want me to reread the question?
Yeah, go ahead.
Okay. So, do you recommend incorporating a standalone de-escalation policy as opposed to incorporating it into various existing policies, such as use of force, handling the mentally ill, and so forth?
Well, one of the challenges in having a standalone de-escalation policy is making sure that it integrates with all the responsibilities, like your crisis response unit, your response to mentally ill. So, although I'm not opposed to having a standalone policy, I think it's far more significant to have the de-escalation philosophy interwoven throughout the entire policy manual in a way such as Laura suggested. I think really, as she talked about different policies where there are elements of the de-escalation concept, I really think that integrated holistic approach is best. Now, I recognize that there are agencies that are under pressure to have a buzzword policy. That is, we have a de-escalation policy, and they can trot that out to their oversight board, whether it's a civilian review board or some other entity, and if that's the case, maybe they have bigger problems in that agency than just having a de-escalation policy. But I get it. There will be times when you've got to have a banner that you can throw out there, but I don't think that's as effective as the approach Laura suggested.
Okay. And just for the audience, just so you know, Laura dropped off for a second there, and we're hoping she'll be able to join us again momentarily.
I think she's back.
Oh, okay.
Yep, I'm back. Sorry about that.
Oh. Would you like me to answer the question, or repeat the question again, Laura, or were you able to chime in?
No, I just heard the last part of Ken's answer, so we can go to the next question if you have any.
Okay, sure. Let's do one more question, if that's okay. This comes from Travis. Hi, Travis. Much of the issue with de-escalation is very difficult if the citizen does not de-escalate. It takes two to make this work. How should leaders deal with this issue when they're continually questioned over their use of force incidents?
You know, I'm going to jump in on that one, and I can sense the frustration in that question, because he's correct that it takes two to tango. But unfortunately, you know, as we've indicated throughout this presentation, most of the time when de-escalation is needed, we're dealing with people that are in some sort of a crisis. And I've said for years in teaching police officers on legal liability, you know, these medical calls, these civil commitment calls, these suicidal person calls, they're very difficult to respond to because, you know, the majority of time we're not dealing with people who are, and I'm going to use Ken's terminology, they're not on their A game. They're down to a letter D, and it's up to us to try to, you know, bring them back. And so, unfortunately, we're going to have Monday morning quarterbacks. We're going to have the media. We're going to have members of our community. They may be second guessing, you know, how it was that police officers responded, and you know, they could have done or utilized their de-escalation techniques better than they did. And you know, all we can do, hopefully, our leadership in our police agencies, they recognize, you know, the fact that our officers are trying, and we're hoping that the leadership in our agencies, they don't have the knee-jerk reaction in responding to the Monday morning quarterbacking. And all we can do is educate the members of our communities on, you know, the fact that we're trying, we're incorporating de-escalation into our training or procedures, and we, you know, address it in our policies, but it's not going to be perfect because as I indicate to individuals in my closing arguments for a lot of these types of cases, is human being is unpredictable. So how is it that, you know, police officers can predict what the next move is going to be by the individuals that they're confronted with? So with that, I don't know. Ken, do you have any other comments on that?
I don't, and other than to say, you know, I encourage all the chiefs, the sheriffs, the lieutenants, the directors, the administrators online, provide your folks with the best tools you can, but then step back and understand that at the end of the day, policing is a profession of humans. We're policing humans with humans.
That's a
really
great
good
point.
Yeah.
That's a great
hey,
point.
you know, I had said that might be the last question, and then I saw a question that it's something that I've been talking about with Jim Glennon of Calibre Press a lot lately, and I just would really like to get your take on it. The question is, in a suicide situation, when there's no threat to another person, can officers or agencies be held liable for leaving the scene?
Yeah, you know,
do you want to address that first?
Yeah, if you take that in the traditional analysis, if you went out on the street and asked 100 cops, I think 99 would say, "Oh no, we have a duty to act, we have a duty to intervene, we have a duty to save people from themselves." And then there's going to be that one cop who says, "So wait a minute, you're threatening to kill yourself, and you show up and force me to kill you. I don't see how that's a good outcome." So my answer is no. And from a lawyer's perspective, the answer, surprisingly, the short answer is no. But there are a lot of practical training and policy discussions that should be happening in your agency on this question. And I applaud the agencies that are stepping up and asking this very difficult question. There's a feature article in next month's issue of Police Magazine that addresses at some length the policy training and legal questions surrounding this issue. Just like we can't always de-escalate, frankly, we can't save everyone. We can't save everyone from themselves. So I appreciate that people are thinking about that hard issue, and I think it's very indicative of the quality of folks we have online today. And with that, I'm just going to thank everybody for your time and sharing an hour with Laura and I, and then turn over to Laura for any final comments from my friend.
Yes, I just have one final thought, and it just kind of follows what Ken stated. We need to teach officers the difference between a moral duty to do something, because again, as he noted, we have on our squad cars a duty to serve and protect. Well, that's the moral duty. And I stress that because there is a huge difference between a moral duty to respond and protect versus a legal duty to respond and protect. And there's a huge difference. And unfortunately, you know, that's a whole nother presentation that perhaps we can address another day. But keep that in mind, because there's a big difference. And so, like Ken, I want to thank everybody for taking the time out to spend the hour with us to talk about this and listen to this very important topic.
Well, again, thank you guys so much. This has been very interesting, edifying. It's just been very good all around. And just again to reiterate, the article that Ken referenced is going to be in Police Magazine. The article is written by Ken, and keep an eye out for that. The other thing that I'd like to just remind everybody of is to go ahead and visit this link here, info.lexipol.com/de-escalation-policy. So go ahead and click on that for a lot of more very good information. Thank you all for attending, and please keep in touch with Lexipol and Calibre Press, and stay tuned for more. Thank you.
Thank you, everyone. Have a great day.